Hello and welcome to this SCL webinar. SCL is the leading educational charity for the tech law community. Membership of SCL is open to all. If you're not already a member, joining details can be found on our website. Membership is free for trainee lawyers and for students. If you'd like to ask a question during this webinar, please use the Q&A or chat section at the bottom of your screen. Thank you for joining us today. We hope you find this webinar useful. If you'd like to show your support for SCL, and in particular our student schemes, please buy SCL a coffee at buymeacoffee.com/SCL.
Before we get started, I'm just going to level set a little bit in terms of this discussion, and then we will introduce our fantastic panel of speakers and get into the conversation. So the tracing app and the conversation around it, that's why we're here today. And this is a follow-up to a Tea and Tech session we had. And for those unfamiliar, we're having these every Wednesday. They're very informal conversations. And we had one off the back of the Ada Lovelace rapid review of evidence around tracing apps. And we had 80 plus people, and the conversation really started to get going. So Trish and I were thinking, actually, this deserves a deeper dive. And that's why we're here today. So it is a deeper dive. No doubt conversation will explore the centralised model that NHSx is adopting in the UK. We might be discussing the decentralised model used elsewhere, the Google Apple API, perhaps you might know it that way. And we'll be looking at the various issues in terms of adoption of any new technology, the ethical side, the safeguards, and so forth, by reference to what's going on in the UK, but more broadly as well, if we can. We would love to hear from you, and as we discuss and as our panelists speak, if you do have key issues and questions, please do type them in, because we'll keep an eye on that as much as we can. So we have a load of things we'd like to talk to Lilian, Adam, and Tim about, but if there are key things arising from you, we'll pick those up as well. It's fantastic that we've got this panel today, because we can look in some detail at two new bills: the Coronavirus Safeguards Bill that Lilian will discuss, and the Digital Contact Tracing Data Protection Bill that Adam can describe too. And in an hour or so, hour and a half or so, you'll be going back to work or lunch or wherever it may be, and we're thinking, what would we like you to take away? We'd like you to take away a good understanding, a clear understanding of the UK perspective, and an understanding of the sorts of issues that are being debated and that come into play when any new technology is being deployed in this way. So enough from me. Let's introduce our panel. I'll keep talking for a second. Tim, I'm going to introduce Tim Clement-Jones, Lord Tim Clement-Jones first, who'll be known to many of you. I'm lucky enough that I've been a colleague of Tim's for the past 15 years. But you may know Tim as the chair of the Artificial Intelligence House of Lords Select Committee and the co-leader of the all-party group on AI. You may know Tim because of his involvement in pretty much every digital economy bill over the years, and of course, huge involvement in the GDPR as well. Tim, you're a self-declared obsessive in all matters technology, but you have another string to your bow as well, which really comes into play, I think, in this conversation, which is that you were previously the health spokesman. So I think that brings the second axis right into play. Have I described you properly, Tim?
You have, and of course that is quite interesting, because as I will say in a few minutes, it isn't all about the tech. Actually, what we've got to try and hold on to is the fact that this tracing, testing, isolation program is for health reasons, and it's designed, to get our economy back. It's got a social purpose. It's not just about the tech. So, that's going to be one of our discussions, I think, how, we've kind of just got obsessed. And of course, I'm as guilty as anybody. We've got obsessed by the tech. Whereas I think what we've got to do is look through, and there may well be data issues about the human aspect of this, not just about the tech aspect. So I think, we can't get overly distracted by the app itself, although of course that's given rise to a lot of concerns.
Great stuff. So they're the sort of points we'll be hoping to pick up just shortly. But before we do, Trish, can I come to you to introduce our other panelists, please?
Fantastic. I would like to introduce Lilian Edwards right now. She is a professor at the University of Newcastle. She is well known to most of you probably through her a series of writings in the area of e-commerce law, information technology law, the internet law, and artificial intelligence. I know was one of the grounding works that I ever read. One of my first books was one written by Lilian Edwards that I read for my training contracts. Lilian has been significantly involved in this area for many years now, and of late she has been significantly involved with the COVID-19 project. She has been a co-author and lead author on the Coronavirus Safeguards Bill, and has been invited through her work to the NHSx Ethics Advisory Board. Is there anything else you'd like to mention to that list, Lilian?
I'll just unmute. No, that's very flattering. Thank you. Always someone's read your book.
So then Adam, thankfully, is a barrister at Doughty Street Chambers and is an experienced human rights and public law lawyer with a strong civil law background. He has very much been involved with the COVID-19 project of late, having been assisting the Joint Human Rights Committee on drafting the bill proposed off the back of their government report, and we will hear more about that proposed bill and its next steps journey later. So now back over to Tim then for his first talk.
The first thing I wanted to say, and it's a slight addition to what I said to Mark earlier, and I hesitate to say this in the presence of a bunch of tech lawyers, it isn't all about the tech. You know, there is an overarching aspect to this, so there's a social purpose to have an effective track, trace and isolate system. And even with a manual system, we need assurances about data use, etc. But of course, we don't have a data impact assessment published yet, even for the manual track and trace, which has just begun to be put in place. So, you know, the transparency, etc., even for the manual side is not yet there. And it does remain at the end of the day that the human-centered approach is absolutely crucial. And of course, that's one of the issues that we have with artificial intelligence. If people get over-obsessed with automated decision-making, then that tends to obscure some of the real live issues that are out there. So there are sort of general lessons, I think, to be learned from the application of the COVID-19 app. Tech does have its particular issues, however, and I think what really impressed me at the very beginning, just before we went into lockdown, Yuval Noah Harari, in a March Financial Times article, he said, in times of crisis, we face choices, either totalitarian surveillance or citizen empowerment, and nationalist isolation or global solidarity. Now, that absolutely struck a chord with me. Of course, he's talking about the extremes, but it does mean that what we do have to think very carefully about is exactly what we're trying to do in the midst of all of this. And of course, trying to get soundings, trying to find out what's really happening is, you know, one of the arts that you have to cultivate as a parliamentarian. And I was very lucky to have a call from Dr. Michael Veal, who works very closely with Lilian, Dr. Michael Veal of UCL, and he first got in contact with me, and I feel extremely as though I've been on speed or something, because this was only the 13th of April, for heaven's sake. And he talked about the decentralised app that he and many other academics, many other colleagues in Europe were developing, called the DP3T app, Privacy Protecting Proximity app. And he was saying that actually what was happening was that the NHSx, the newly formed, if you like, digital bit of the NHS, were trying to develop something that wasn't the same, wasn't compatible, wasn't as secure in terms of data, and you know, also had other issues to do with the Apple and Google Bluetooth protocols. So, you know, my first instinct is, because I'd worked with Michael and Lilian on a data protection bill, now Act, 2 years ago. They were extremely helpful in picking our way through the GDPR. So I thought, well, look, I better listen to this. So I asked a couple of parliamentary questions, and the way these things work, it takes a few weeks before you get the answer back. But it was pretty unsatisfactory, quite honestly. We got the usual blandishments, saying everything was absolutely fine. You know, it was all interoperable. They were, and many other countries were adopting the app that NHSx were developing, etc., etc. And of course, since then, the NHSx app has generated a huge amount of interest and controversy, not least a report from the Joint Committee on Human Rights, which Adam advised. And of course, we're now talking about a bill from each of them this morning. And of course, the government has developed somewhat of a bunker mentality. NHSx Act really, extraordinarily enough, does have a bunker mentality. Even they weren't even prepared to engage with Tim Spector over his Zoe app, which, you know, was a purely a functional app designed to see whether or not people are developing symptoms or not. And, you know, I put the ministers in touch. They kept writing back saying, oh, don't you confuse people if the NHS took any interest in this? And yet now we know it's got 4 million people signed up to it. And it's a really important way of seeing whether or not there is actual clustering. So there is a cultural aspect here, quite apart from the legal aspects that we've talked about. And we've had some really helpful analyses from people like Michael, from Chris Culnane, about the data impact assessment on the app, about the source codes and so on. And the fact is that the DP3T app, it may have its critics, but the fact is it's the app which other European countries have adopted. And that in itself is in the context of the European Parliament principles, the European Technology Policy Committee approach to these things, which gives me much greater reassurance that this is going to be a proper way of collecting data. It is decentralized, it's not held in a central server, and so on and so forth. And of course, all of you on the call will know that we've had a great many commentaries, Big Brother Watch, Liberty, and above all, the Ada Lovelace Institute. I mean, the ICO has had some involvement, of course, as well. And they say, the way they put it is effective deployment of all technology to support the transition from the crisis will be contingent on public trust and confidence. And for me, that is absolutely, you know, and as a parliamentarian, that is what you absolutely have to secure. So publications by people like Ada have said, you know, what we need in exit through the app, in provisos for a contract tracing app, need for transparency, cross-border interoperability, allow deactivation, transparent oversight, transparency of protocols, time limitation, and so on. And it all adds up to the need for new legislation, which of course brings us on to our two bills today. The fact is, the equivalent Australian legislation was put through in 2 days. Now, if the political will was there, we could do that. And, you know, on my desk, I've got a note from Harriet Harman in the House magazine, talking about how practical it would be to put this through, how she's had, you know, pushback from the health minister and so on. There is absolutely no reason why we shouldn't do that. And, you know, there are provisions in the Australian legislation, and it's provisions that we should have regarding limitation of the use of data, deletion of data on phone and centrally, oversight, prevention. Now, there are differences between the two bills today, and no doubt we'll have further explanation from Adam and Lilian. My own party's proposal does happen to be closer to Lilian's because of concern over potential compulsion. You know, we want to create legal safeguards against discrimination, so no one can be excluded from any space for not having or refusing to use the app. Now, I happen to think that's an important aspect, but by and large, an awful lot of the two bills do have a lot in common. Just coming to the end, I think the role of the ethics board, and of course, it's very interesting that Lilian was invited to be on the ethics board. No doubt she will be indiscreet this morning and talk about the role of the board, I wonder. But the fact is that all the ministerial answers I've had have basically said that they do not have the right, in a sense, to be heard by the oversight board. They can't override what the app oversight board decides. And frankly, if you are going to have an ethics advisory board, they need to have a lot more power and influence than it feels to me that the oversight that the ethics board currently has. So I think the final thing I'd say is that very, very recently it came out that the use of COVID patients' data through this system will be held for 20 years. Now, you know, if that isn't a reason for being paranoid, I'm not quite sure what is. You know, we've been told, I mean, you know, we've been told in Australia it's much more time limited. You know, it's months, not years. I think 21 days is a period that many observers would want to see. So I think we will continue to question. We've been promised a ministerial briefing this week on the rollout, whether that will include the app, because after all, who knows? We don't even know what the objectives of the Isle of Wight project were in terms of the testing, and we don't know what level of success it's had, and therefore we have no idea whether it's actually going to get rolled out. Now, it may be that Lilian, from her most recent ethics advisory board, will know the answer to that, but certainly poor, ignorant parliamentarians have no knowledge as to whether or not that's ever going to see the light of day. We're in a virtual Lords at the moment, which makes it more difficult to scrutinise. We go hybrid next week. I just hope and pray that actually it'll be rather more straightforward to ask questions and get more scrutiny as from next week. Thank you.
Super stuff, Tim. Thanks very much. And I think there's a lot of points there that let's hold in our hands, shall we, and hear from our other speakers. And I'll hand to you in a second, Trish. But just, Tim, you've raised a number of things that we might want to discuss more deeply as we go on. The societal impact, I think, we've talked, and you've mentioned those that do and don't have access to technology. The Australian example is illustrative, isn't it? Secondly, I think the ethics board and the whole piece you're discussing there around adoption of new technology generally. I mean, this is an object lesson, isn't it, in doing something very quickly for the right reasons, but against the themes that we've seen emerging from the work you and I've done on trying to crunch together what's coming out of the OECD, Council of Europe, G20, Partnership, AI, and so on, around the need for transparency, explainability, accuracy, all these key themes. So very interesting to see how that comes up. And you mentioned at the end there the Isle of Wight and the Isle of Wight learnings, whatever they may be. Not entirely clear just yet. So thank you, Tim. That's obviously got us off to a roaring start. So Trish, I'll hand over to you.
That's brilliant. And I think that's a really good segue into what I'm hoping Lilian will be able to do, pass on to us with her knowledge and experience on this journey. You can see when you look at the coronavirus safeguards bill that some of these elements have been picked up, the cultural, the societal, the potential for stigmatization, the potential for new kinds of discrimination, the potential for this to be taken into the workplace and to really cause a real barrier for people to come back to work. And also thinking about the digital divide, thinking about, you know, what about the prosecutions of people, or the potential for prosecution if people leave their phones at home or inadvertently turn off their location data or their Bluetooth connection there. So many of these things have obviously been thought out by Lilian and the others who have partaken in the group. Now, last I knew, it was at version 5.1 on the 6th of May. You may be able to update me on that and us on that, but we'd love to hear about your journey as to how you got to the coronavirus bill and where you plan to take it next. Over to you, Lilian.
Thanks. That was all very interesting, especially some of the bits from Tim. Thanks. So maybe we can pick up on some of those in questions. But yeah, my bill, or our bill, because I was the primary drafter, but there was a team of people who came in with expertise in data protection, public law, and human rights to whom I'm very grateful. The full list of those names is on the bill, which is available online. If you just Google for coronavirus safeguards bill, you will get it. Yeah, the first version was written on the 13th of April. We've actually renumbered the versions to be less confusing, so it now says version 9 on the 6th of May, and I haven't really updated it since then for reasons that I might come to. So the background of this was that, as Tim was discussing, I was aware quite early on about the DP3T decentralised project because I do a lot of work with Michael Veal, who was very involved with it and remains very involved with it. And that was the decentralised project that was picked up, as I understand, partly by Apple, and contributed a great deal to the decentralised protocol that has become the GAPL, the Google Apple offering, and which has become really the dominant paradigm for Europe. And as I understand it, it's now only the UK, France, and I think still Norway, though dithering, that have gone for the centralised model. Okay, so we're now very much in the minority. So with that background, I was worried, and now in a way this seems a quaint worry, that the debate was being regarded as solved entirely by the technology. The debate had become very heated between privacy proponents who saw the decentralized model where the data that is collected is held purely on people's phones, and there is no proximity data, this data that's gathered by Bluetooth as to whether you've been near somebody who is infected or potentially infected. So that proximity data is passed from phone to phone, and alerts are passed in this decentralized fashion. And there is no collection of the data centrally, right? In the centralized version, which is what the NHSx has gone for, there is central collection of data which is pseudonymized. It's related to you by a persistent pseudonymous identifier. But as everyone here, I think, will know, that is still personal data in the GDPR, and it can be used potentially to track you for the time ongoing. So there was a clear interest from privacy advocates in going for the decentralized model. And I just became worried that this debate was boiling down to a simple choice of architectures, when it really wasn't quite that simple. Because whatever architecture you choose, there are clear privacy advantages of the decentralized model, but whichever one you chose, there would still be social implications as to how these technologies were embedded into the social context. And to make that seem slightly less airy-fairy, you know, one question that I was asked a lot a month, 6 weeks ago was, you know, what if I don't have a phone? What if I forget my phone? What if my phone isn't charged? What if my mum, and I always use my mum, doesn't know how to turn on Bluetooth, you know, or goes out the house with the charge level dangerously low? Is there any chance that she could be in some way penalized? So it seemed to me as a start that it was necessary to have an explicit safeguard in law. And this has been one of my hobby horses before Dominic Cummings, you know, that law you can rely on. Guidance is interpretable and can be changed and withdrawn and so forth and so on. But law is law, and at least has some quality of the rule of law about it. So that there should be a legal safeguard that said that no one should be penalized for this variety of options I just mentioned: not having a phone, leaving the house without a phone, failing to charge your phone, failing to have the protocol enabled of Bluetooth, etc., etc. And that seems to me to be a basic autonomy and fairness issue, particularly as those most likely to not have a phone or to not know how to handle it will be the most disempowered, will be the poorest, the oldest, the least technical literate. That's what the stats show, okay? So that one in a way seemed to be a no-brainer. And we can discuss this, but I'm quite surprised that it's not actually in the Joint Human Rights Bill. However, having said that, I regarded that as a no-brainer and as something that should just be ensconced in law. I think the key message and the key point where there's going to be argument is about whether you can be incentivized, required, mandated to install the contact tracing app on your phone, and more importantly, perhaps, whether you can be required then to show it to, say, an employer or to somebody running a public space, like a football stadium or a shopping mall or a GP's waiting room, anything like that. So is it going to become a badge, a guild entry, a certificate to allow you entry to social life, to work life, to earning your living, etc.? And that worried me, because what we always see with the introduction of new technologies is that they marginalize or they discriminate against those already least empowered, the poorest as say the least technical literate, the ones in the precarious jobs, the 0 hours economy, the gig workers, the ones who perhaps belong to ethnic groups, okay? So my worry was that that might happen. And then you get into an argument, because you might say the whole point of having the app for the benefit of us all is that everyone be compelled to use it, right? And in there, you've also got this research stat that the tracing only really works well if you have 80% of the smartphone owning population using it. And since about 20% of the population don't have smartphones, that gets you down to about 64%, which seems to have been revised down to 50% in recent epidemiological announcements. I'm not quite sure on what basis, but they're now saying 50% would do to make it really effective, okay? And then there's an argument, people like John Crowcroft always make at this point, that in fact it's effective if anyone uses it to some extent. Okay, so there are clear societal incentives to say you should install this thing and keep it running. And then there are the incentives of those like employers who might say, well, we want to have a clean workplace. We want to make it safe for people to work there. We don't want our staff to constantly be going off sick, et cetera, right? So you might say maybe compulsion is allowable. And I'm already aware of quite a lot of employers, public and private sector, who've been fishing around inquiring about this as to whether they were allowed to do this, to require that their employees had the app and perhaps also displayed the messages on it. But as I say, you've got the point that this is being used as a proxy for health, and it isn't a proxy for health. Having the app says nothing about your health. It's very likely to just sit on your phone and do nothing at all. What it's doing is enabling the tracking down of other people who are unhealthy, potentially, okay? And even if you receive a contact notification on your phone, that still doesn't mean that you're necessarily ill or infected. Even though, because we know that there are going to be a substantial number of false positives, because at the moment, at least, the app relies on self-reported symptoms for generating contact cascades on notifications. And we all know, I think, that self-reported symptoms are extremely unreliable. And although there is going to be some risk scoring at the NHS back end to try to reduce that cascade of false positives, it's by no means clear from anything I've seen what percentage of false positives will emerge to real positives. And finally, if you add to all that, the fact that there are groups who are very worried about having the app at all, and this goes back to the no one shall be penalized point. So the two that I've heard most mentioned are people who are of ethnic groups where they're worried that, say, this might in some way be used to prejudice their immigration status, or that it might be used in some way to connect them to say radical or terrorist individuals. Now, these may be completely false beliefs, but they may still lead to substantial non-take-up by certain groups who will then perhaps be discriminated against unreasonably if the app is used as a means to exclude them from the workplace or from public areas, yeah? So all in all, we had a discussion about this really in the various iterations of my bill. First of all, what we went for was a proportionality analysis, which is probably very familiar to people who know human rights. So we said that in general, we'd rather that there wasn't requirements, mandates of this kind, but they could be justified if they were transparent, if they were in pursuit of a legitimate goal, if they were necessary, which is a high test, and if they were proportional to that legitimate goal of protecting society, protecting the workplace, whatever. But then the Australian bill came out, and somewhat to my surprise, they had actually gone for no compulsion period. And that Australian app is also a centralised app, gathers a lot of information, is probably more intrusive, in fact, than the NHSx app from what we know of it so far. And they had chosen to go down the line of just no one shall be compelled, right? And at that point, we had a discussion and decided that that was probably the right way to go with, as I say, this app, which is not itself a proxy or a guarantee of health. Now, where this gets interesting, I think, for the future ongoing, is when we get to immunity passports, which I think is going to happen. I mean, it's really interesting how the discourse on this has really shifted very quickly over the last couple of weeks from, oh no, you know, we're never going to get there, the science isn't there, we don't know if antibodies prove immunity, to now where the concept is being bandied around quite a lot. And I think it is going to happen at some point. And now you can buy your immunity test, your antibody test, I should say, for £79 from Superdrug. So, you know, the public uptake of these things is becoming apparent. So when you get to immunity certificates, the whole purpose of them is to discriminate. Yeah, that's what they're there for. They're actually to, in some ways, perhaps say, you can't travel, you can't leave the country, you can't enter this country, you can't get on a plane unless you've got the immunity certificate. So at that point, I think, again, although there is an argument for their legality, I think you really, really need your proportionality analysis at that point. Or the two very quickly, very easily become a combination of a digital ID card and a means very easily to discriminate either against individuals or against groups, societal groups. Okay, so again, we suggested in the bill that although we were looking forward to a technology which didn't exist yet, that there were two major bright line safeguards that we wanted in place as a precautionary measure. One was that they should not become internal passports for anyone but the police. It seemed completely against the background of English human rights and kind of autonomy measures. For, you know, a policeman can stop you doing things, but I don't think that a private body, a company, whatever, should be able to say you can't travel. And the second point we then made was, yeah, that the proportionality analysis that I've just outlined should be applied to any requirement to use or display an immunity certificate. So that's kind of the main measures. One thing I should have said maybe at the start, which is rather different about my bill, our bill, than the Joint Human Rights Bill, which is, you know, beautifully drafted, but seems to have started from a different premise. We started from the premise that data protection existed and we weren't going to reinvent the wheel. So there were quite a lot of measures by which I would refer you back to data protection, such as, for example, the right to delete any of this data that's held in the hands of the data controller. You don't need to say that again, right? But on the other hand, there are areas, I will say data protection is enabling rather than prohibitive. There are lots of ways to get to your goal via data protection. And so there are places where you really could do with specifying. And the most obvious, which is mentioned in the Joint Human Rights Bill, is deletion, is sunset clause, retention. There's been these various phrases used. And yeah, as Tim highlighted, this is becoming a very confused area because we have at least 3 sources of personal data wandering around the place now. We have the app, right, which collects pseudonymous but personal data, which NHSx continually claim therefore has very little privacy risk. I don't know if we can establish that. We don't know what data it will be combined with. We don't know how long it will be held. All the DPIA that we've currently seen says about that is that the data should be held as long as necessary, right? As long as a piece of string. The test and trace DPIA that we haven't seen yet, but the privacy notice that we have seen says 20 years for your personal data and 5 years for the personal data about the other people that you give information about. Now that's confusing the public a great deal, I think, and it's not at all clear where these numbers have been taken from. As Tim was saying, the argument about having personal data about an individual who's infected should imply that that data is useless after about 21 to 28 days. And that's the attitude that New Zealand, for example, has taken. If you're talking about that data being retained for long-scale research, which I think we'd all agree is necessary, then why shouldn't it be anonymized, which is normal NHS practice or normal medical research practice? Now that in itself, for me, also raises issues because we all know, I think, that anonymization is in fact not a get-out-jail-free card, and there's again substantial evidence that if you take a large data set of the sort you're going to get from the manual tracing strategy, and again, you combine it with other data sets, which might be held by NHS, might be held by other parts of the government, might be held by private contractors involved like Palantir, then you're going to be able to re-identify. You just are. So I don't know what the solution to that one is, but I do think we need to start from a position of looking at what data needs to be kept in personally identifying form, to use the American phrase, which you shouldn't do, and what data could be anonymized, and what data could simply be deleted. We need to face up to this one and think about actual deletion. Or we need to start talking about clever means of making that data less re-identifiable, such as differential privacy. I've probably gone way over my time, so I should stop. I'll just mention, because the place where the two of us agree, I think, and you can cut this, I don't know, the recording, is on the need for new forms of oversight. And I suggest that a coronavirus safeguarding commissioner, maybe Adam, probably talk more about that in his, and I'll stop.
Thank you very much for that, Lilian. That was really insightful, and I think that clarity. Someone in the Q&A wanted to a little bit of clarity over the distinction between the DPIA for the app and for the test and trace strategy, and also for the manual tracing. So thank you very much for clarifying on that. Yes, Adam, the bill you've been tasked to draft, I'm sure with others, but off the back of the Joint Human Rights Committee report, I'm sure it's been quite a long journey. It's been spearheaded by obviously Harriet Harman and Fiona Bruce and others in the Human Rights Committee. Would you like to tell us a bit more about that journey? Obviously, there's been quite a focus on a commissioner separate from the Information Commissioner's role, much to the ICO's delight, I'm sure. So yes, we'd love to hear a little bit more from you about that, if that's okay.
Thanks so much, and thanks so much for having me. I'm an independent barrister, and at the moment I'm acting as special advisor to the Joint Committee on Human Rights. I'm not speaking on behalf of the Joint Committee today, and in fact I should very strongly point out that the bill that's out there from the Joint Committee and the report. So I've just, if you look in the chat, I think everybody should have 3 links. One is to the Digital Contact Tracing Data Protection Bill. The second is to the evidence session. So the Joint Committee heard evidence from the Matthew Gould, Elizabeth Denham, the Information Commissioner. So Matthew Gould is the head of NHSx, which is developing the Act. Simon McDougall, Dr. Ian Levy, and I think there was one other. Anyway, there was an evidence session, and I've posted a transcript to that, and I've also posted a link to the report which came out of that. And this is all a long roundabout way of saying that the bill emerged as a product of the report, which is from the Human Rights Committee, and it's certainly not from me. I assisted in drafting the bill along with the council team. But what I can do today is to sort of take you through the bill. And I think also I should say, by way of introduction, that Lilian's bill was certainly, and Lilian et al.'s bill was certainly in the minds of everybody who was working on that as well, was extremely useful. And I think fundamentally, there's no great disagreement between the 2 different approaches. And in fact, if this bill was taken up, so for example, I saw that Harriet Harman responded, I think to Lilian or to somebody else on Twitter, that in relation to the not forcing people to download the app or use the app, that was something that the committee was considering. But the important thing at that stage, this was a week or 2 ago, was to get the bill in some sort of form that it had a prospect of getting into Parliament. And I noticed this morning as well that Jacob Rees-Mogg, in his capacity as, is he chairman of the House? I can't remember the expression, but he controls parliamentary business, has said no, the government is not going to take up this bill, just as Matt Hancock has. So the reality is that the government is not interested at the moment in any kind of separate legislation, and its position, which is made very clear, and I will post links to the letters, which are also on the Joint Committee website, that the government's current position very clearly is that they don't believe that any kind of separate legislation is necessary at all, and they believe that all the existing protections are sufficient. But with all that in the background, I'll just summarise briefly what the bill does and just try and give you an insight into why. So I'm just going to split it into 10 things. The first thing is to enshrine in law the privacy guarantees that have been made sort of in of evidence to the oral evidence by Matthew Gould to the Human Rights Committee, and various statements by the Secretary of State for Health. They've said this is what we're going to do this is the purpose of the Digital Contact Tracing App, and this is all we're going to do with it. And of course, in the context of GDPR, once you've set the purpose, that's the only purpose you can use it for, and everything has to be necessary for that purpose. But what the bill does is it sets the purpose down in law, and I'll tell you the exact purpose. This is section 2 of the bill, clause 2 of the bill. Permitted contact tracing purposes. For the purpose of this act, the purposes mean protecting the health of individuals who are or may become infected with coronavirus, and preventing or controlling the spread of coronavirus. And I think one of the target of that specific purpose, amongst other things, was to make sure that the data which is collected for this very important purpose is not then repurposed in the future, which you can imagine happening. And this idea of mission creep, that you've got this really important data set which shows how a virus spreads through a population in quite a dynamic and thickly set out way. You can imagine that data set then being used for the protection of other in other epidemics, or helping other countries deal with their epidemics. That's the purpose. That's the reason for restricting down the purpose. It's not to stop the NHS using it for useful reasons. It's to stop it using it for lots of other reasons that aren't currently in people's minds. So a second thing that it does is creates criminal offences for the misuse of the data, which sort of it builds on what's already there in legislation. Third, ensuring transparency. So there's a lot of transparency elements to the bill, and this picks up on general issues that I think the Human Rights Committee has identified in its published reports in its COVID-19 inquiry. And of course, this subject is not the only subject that the Human Rights Committee has been dealing with in its COVID-19 inquiry. It's just one of a number. But one of the themes which has come out also in the lockdown law context, so in the regulations that are creating the lockdown law, is this legislation by fiat and a lack of appetite for scrutiny. And I don't say that in necessarily as a deep criticism of the government. I can kind of, as someone who used to do quite a lot of work for the government, and I don't anymore, I can understand in the deluge that the government's in at the moment that if you can avoid scrutiny, then, all the better, just get on with the legislating. But the problem is that you end up creating bad laws, and you don't have, and I think this is the most important thing in relation to civil society, you don't have a feedback mechanism. You don't have a means whereby you can regularly understand the important and expert feedback that's coming in from civil society through and the normal way of that happening is through mandatory parliamentary reports, for example. So I think the bill suggests regular mandatory reports on the proportionality and the continuing proportionality of the digital contact tracing app, so that it forces the Secretary of State to sit down every month and write down very clearly how the app is working. Have new problems arisen? Is there a reason potentially now for tweaking the way in which the data protection works, etc., etc., etc. And we're just not getting that. For example, with the lockdown laws, and I focus on that because it's been another one of my work streams. It's been the lockdown laws. There's meant to be a review every 21 days. It's in the regulations, but the Secretary of State sort of published after 21 days after the initial lockdown regulations a very perfunctory review, which was a couple of paragraphs long, and now he's just not bothering at all, and that's it makes for worse laws, because then you're amending the laws based on a kind of an absence of feedback. So that transparency piece is quite an important element. there's a provision on re-identifying and de-identifying data, and really what's going on there is, again, building on what's already in GDPR, that once this data is uploaded, it's been a bit that the government has been, and the NHSx have been a little bit loose on whether, first of all, whether they'll be collecting personal data. Second of all, when data will be personal data and when it won't be personal data. And third of all, what they consider to be re-identifiable data. And what I mean by that is the technology experts will be better at this than the lawyers. Clearly, there is some data which in and of itself is not attributable to an individual, but in conjunction with other data sets will be attributable to an individual. So for example, if you have somebody's movements and but based on a cipher, so you don't know what their identity is, then just by having their movements, you're not going to be able to know who they are. But if, for example, you manage to hack into Google Maps and do have somebody's movements based on their identifiable data, so when they've used Google Maps, you might then be able to combine those two data sets and have a very rich picture of that individual's movements. So that's the big issue really with cloud-based data, is that you can be picking up, you can be calling something non-identifiable data, but in reality, whilst it is linked to somebody's postcode or whatever, however they're going to do it, it can be re-identified. So there's a sort of nailing down of what that means. There's a new regulator, the Digital Contact Tracing Human Rights Commissioner, and you can read the report for the concerns that the Human Rights Committee had about giving this to the Information Commissioner. I express no personal view on that at all. That it's simply it's a concern of the Human Rights Committee that the Information Commissioner might not, for various reasons, be the right person or institution to be regulating this aspect of the of data privacy. So security reviews, there's a requirement to have and certify security reviews every 21 days, and that's to be done by the National Cyber Security Centre, and that's simply to keep a regular review going, because these the technology can change very quickly. Issues can be identified, as you can see with the particularly with mobile phone software. Vulnerabilities are identified all the time, and they have to be patched very, very quickly. And that, I'm sure, would happen with this app and with this database as well. But the important thing is to ensure that the Secretary of State doesn't just do one review and say a year later, well, I did a review a year ago. What's the problem? And it's been hacked into. So it's those regular reviews. There's what's the right word? Ensuring that the contact tracing data which is collected on a mobile device is secured by consent. Rules on deletion and anonymization of data. And then finally, there's a number of requirements for publication. This goes back to transparency, not just reviews, but all data protection impact assessments must be published, that the information relating to the design and security of the contact tracing app, and also minutes of meetings and reports by the Contact Tracing Ethics Advisory Board. So including Lilian's contributions, I imagine. But that would all have to be published on a regular basis so that this can be as open source, to use the technological expression, as open source a process as possible, to ensure that any issues which arise can be highlighted and dealt with in real time. Not because, and I think this applies to across the piece with coronavirus response legislation and policy making. it's not a case of wanting to criticize everything the government does. And I think that sometimes the government goes back into its shell, assuming that criticism is a sort of unfair or not worth engaging with. But I think that there's a very large impetus when things are being done so quickly and with such impact on people's rights and with such a impact on people's everyday lives, that there is a really good architecture for constructive engagement, and that's really all that is being sought, as well as sort of tightening up those data protection requirements.
Thanks very much, Adam. Fascinating hearing you describe that straight after Lilian described the other bill. And one thing really leapt out for me that you said, Lilian, was that you started from the premise that data protection law exists. No need to reinvent. And Tim, you and I were at an event where the speaker from the European Commission in their white paper took a similar approach. The law exists, we're not reinventing. I was just looking at some of the links that you were sending there, Adam, and looking around your bill as well. And Harriet Harman's quoted as saying, the current law is an unsatisfactory mishmash spread across GDPR, DPA, Article 8, ECHR, and case law on rights to privacy. So potentially we've got these sort of two conflicting viewpoints here, haven't we? One, that the law already exists and it's fine, don't reinvent, but another perhaps saying that may be, but it needs to be drawn together specifically for COVID. Where is that a correct analysis? The difference there. I wonder, Tim, if you want to come in on this at some point too.
Funny enough, the one thing that I was very interested in was the commonality, actually, in the course of the discussion. I mean, I agree with you that they come from different directions, but at the end of the day, I mean, give or take 2 or 3 clauses and maybe slightly different phraseology, I think they're what I tend to focus on, maybe because that's the way my party operates. We try and see the commonality rather than the differences. But I think you're right, probably intellectually, but at the end of the day, practically speaking, it may add up to the same thing. But our 2 experts probably are better qualified than I am. I mean, if it was up to me, I would do a sort of, I'd conform the 2 and see where the joins are, basically, and be a bit of a magpie and take things from each of the bills, because I like a statement of purpose, for instance, but I also like, the non-discrimination aspects and so on that Lilian was talking about. So, I think you pay no money, but you still take your choice.
Yeah, I mean, that was very interesting, actually, because I've been dying to know why the Joint Human Rights Committee made the choices it made. And I absolutely see that the aim is to get a bill that might get some parliamentary time, right? So the nearer that is, it seems to me, to what we accept as law already, which is data protection law, but providing more specificity about notably security and repurposing and sharing. The more chance there is of that being seen as a viable kind of machine to get into Parliament. And I've said jocularly a few times, but I'm actually deadly serious. But I would really love to see this bill get some parliamentary time, and then I would ask Tim to write amendments to it, parts of my bill. So I started drafting the coronavirus safeguards bill as a kind of an academic experiment, because I'd actually just been ill myself, if you want the human interest story, with the virus, and I wanted to kind of contribute something. So I did very much a gap analysis. It's the way I tend to think. What have we got? What are the gaps? What's really important? And also, as I say, it was a reaction against this kind of prevalent techno-solutionism. It wasn't designed with an explicit political goal of actually getting into Parliament. In fact, at least 2 parliamentarians told me that there was not a chance in hell it would ever get into Parliament. We've started from, and it's very gratifying to see then that 2 weeks later the Australian Act came out, which very clearly had some DNA in our bill, and then to see the Joint Human Rights Committee obviously paying a little bit of attention to it. So there you go, that's the kind of human backstory. So, Adam.
Yeah, I mean, again, I can't take as much credit, or any credit really, as Lilian does, because I'm sort of more the pen than the holder of the pen in that process. But I think that I think certainly from Harriet Harman's engagement with this, I think her concern is getting something out there, just as Lilian's concern was, and she's clearly, from her tweet that I mentioned, she's perfectly willing to listen to different ideas for how to achieve it. I think what a couple of points that I wanted to make, as I guess for discussion, was first of all the framing of this issue of contact tracing, not just digital contact tracing, but contact tracing generally. And I think one of the questions I've had over the last few days, when the what's described as manual contact tracing system has come into operation, is, have we focused enough on the so-called manual contact tracing, which itself, you know, it's only manual until you stick it into a database. so rather than the app being the interface between the human and the citizen and the database, there's an individual in a call center who's the interface. And in fact, I think a lot of people would find an individual from a call center calling them up and asking them, you know, all sorts of pretty invasive questions. I mean, super invasive questions. You know, who did you have dinner with last Tuesday? Let me get that name. Yes, and how close were you to that person during the dinner? Right, and for how long? I mean, and this is a person who may have just got, apparently there are 20,000 contact tracers who have been employed in the last few weeks. And God knows who these people are. You know, are they sort of, what are their experiences? How are they being trained? And how on earth is this going to work? And how invasive will that be? And have we been framing the digital contact tracing app in the wrong way, possibly? Because the digital contact tracing app potentially liberates us from the necessity to have to go through the manual contact tracing process. That's just one question that I wanted to raise. And the second point is, I think there's a slight, I've noticed a tension between who I describe as sort of lawyers and parliamentary draftsmen, parliamentary counsel, and perhaps campaigners and parliamentarians, between the idea of an act which sets down people's rights in plain English, that is short and that people can understand and read, as an improvement on the having to sort of guess the interpretation of the GDPR and the Data Protection Act 2018. And the tension, I think, is that lawyers and parliamentary counsel very much disparage the idea of legislation for the sake of clarity and for the sake of sort of, you know, public education, if I put it like that. Whereas I wonder if there is a justification for legislation for other reasons, but also for that reason, to having a place where people can go to just be able to read a very simple set of purposes, protections, and restrictions which are relate specifically to this app. So those are my 2 points I wanted to raise for the discussion.
I could
wants
just
to
come
say
back.
something.
Yeah, I just wanted to come back on what Adam said, because sadly he missed the first paragraph of what I said earlier this morning. Because I did say that I thought that actually it wasn't all about the app. It was much more broad about the tracing and tracking human element of all of this. And funnily enough, I was having a discussion this morning, a theoretical discussion with my wife, and said, well, if somebody rang you one morning and said, oh, hello, I'm from tracking and tracing, you know, I'm here to help, or whatever the expression would be. And I'm afraid, you know, you've had contact with somebody with COVID, you're going to have to isolate for 14 days. You would say, well, who the hell are you? You know, how do I verify the fact that you are who you say you are, and you really are acting on in an official capacity, et cetera, et cetera. Of course, if somebody comes to the door with if you like, a warrant or a card that gives their identity and so on, you're much more likely to respond. But I think there are issues of trust public trust, which apply right across the board. And I think Roger Bickerstaff on the chat line has said, Matthew Gould said, if privacy were the only thing that we were optimizing for, a decentralized approach could well be the default choice, but actually we're balancing a number of things. We're balancing privacy with the need for the public health authorities to get insight into. Actually, what Matthew Gould seems to have completely forgotten in all of this is the need to retain public trust. And that, to me, is the overarching aspect to it. And, you know, even if it's the NHS asking for your data, it isn't necessarily, people aren't necessarily going to comply. You have to build that trust.
Absolutely, and it's not really an either-or discussion. It's quite a complex, multi-dimensional discussion we've got to be having. And that makes me question as well whether we should be having not just DPIAs, data protection impact assessments, but whether we should be having societal and algorithmic impact assessments here. You know, really getting to the teeth of some of the ethical issues, some of the privacy issues, some of the autonomy issues, some of the discrimination issues that sit all around this, and not least forget, as maybe us technology lawyers sometimes do, the human rights there and what template that gives for us as a framework to work for and work to. And I just want to come back to Lilian on that then as well, thinking about the way the app has progressed so far. Obviously, we're in beta trial mode over in the Isle of Wight, and we've got the formulation of the NHSx Ethics Advisory Committee. I'd really like to get an understanding and a feel for how that's been formed and whether there is any real governance to this app that we can rely on in absence of codified law right now. And indeed, if we were to push for law, what kind of teeth we should be really asking for here to hold our public powers to account, quite frankly. Over to you, Lilian.
Yeah, there's a lot of points that came up there I'd actually like to address. How much time have we got? About the Ethics Advisory Board, the clue is in the name. We're constantly told we are advisory. We do not sign off on the app. We do not sign off on the DPIA. We advise, we try to bring some expertise. We have obvious gaps in our expertise as well, because it was formed originally around exclusively people with data ethics experience. I was brought in as a lawyer. We don't have any epidemiologists. We don't have any technical people. This is something I would very much like to see. There is talk, and it's no more than talk as far as I know, about us taking on a wider role across the whole track and trace strategy. At that point, that would be a good opportunity to bring in more of this expertise. We do obviously get help. We've had public health people, we've had technical people coming in to give us briefings. In fact, we constantly do get quite a deluge of briefings. So it's not that we're just making it all up. But yes, it's the original role of the Ethics Advisory Board was, I think, quite narrow and has expanded. And it really needs to be rethought in, I think, in a more organised way. We are coming on to talking now quite a lot. Now the kind of immediate panic is receding a little about governance. But I'd also push back, as I'm sure Adam would, on the idea that there is no law here. There is law. There is plenty of law. There is the GDPR. There is data protection. There is the e-privacy directive, which is becoming relevant in terms of public messaging. There is the Equality Act. There is health and safety at work legislation. There is lots of legislation. Maybe it's not apparent to the person reading, you know, the Daily Mirror or whatever, but there's plenty there. And I am in the camp to some extent of not reinventing wheels, of not re-legislating, but that's probably why I'm not a politician. One point I did want to pick up on that I think was brought in by Lord Clement-Jones there is what seems to me to be a real own goal, and I've been going on quite a lot about this in the last few days, and this is my personal view. This is not connected to anything the Ethics Advisory Board has been discussing. It's just because I'm an old sort of law and security hand, which is, it seems remarkable to set up a texting and phoning manual tracing setup without there being some fairly foolproof means of authentication, because this is not exactly rocket science, right? You can use, as many commercial consumer services do, you can use a one-time code. You know, you get this code, you put it into your phone, then you can know that the person you're talking to is the right person. Or as Michael Veal has suggested, you can give everyone a code that they ring a particular number with, and that number then rings them back. So there's various ways of doing this that are really low tech, you know, that you know, will have no problems for grannies, etc. And again, it's an emergency situation. It's still an emergency situation. Things are being set up as fast as possible. We're trying to save lives here. But it does seem that this is something, if it's not there already, which I'm not sure about, having not spoken to a manual contact tracer, that should be rethought quite fast, that we should think about ways of avoiding what seems to me to be an open goal for the kind of scamming on the elderly that we've seen with things like PPI, mis-selling and so forth. Because you are talking about a population that's very easy to prey on, particularly with calls. So that's my little plea, and I've been trying to talk about that in public where I can.
I think it's also something which gets lost in a lot of these discussions since the beginning of the COVID-19 crisis, is the speed at which everything is being set up is beyond, impossible to imagine 3 months ago. I mean, I did an interview with a journalist about, I don't know, a week ago, where he was saying, well, isn't it ridiculous that, they've had 6 weeks now to set up this app, and it's just not available yet. And I said, look, I'm not an app developer, but 6 weeks to set up an app, which they want 40 million people to use to make it effective, which is using new technology, which is using, and it's a new use of existing technology of Bluetooth, which no one in the world knows is going to work yet, which uses it's a completely new idea in terms of a national rollout. The idea of setting that up in a few weeks is totally terrifying, and it's probably going to fail. And in fact, I think you can say the same for the manual contact tracing system. All of the things that we know go wrong with large data sets, with lots of people having access to them, with invasive use of invasive questions of individuals, they're all going to go wrong with it, because they're bound to, because how could anybody possibly get it right in such a short amount of time, when this is only one of probably 10 enormous issues the government is having, just the Secretary of State for Health is having to deal with. If you add in PPE and the lockdown and the, et cetera. So I think they need all the help they can get on these points, and they need all the scrutiny they can get. And I think that's another reason for thinking of more of original and I don't know, if not unprecedented, then new ways of working. Whether it's by does this app need its own parliamentary committee? I don't know. Does there need to be a new commissioner? I don't know. But there has to be a slightly different kind of thinking, and that's not directly me talking, going against what Lilian says about there being existing legislation. There definitely is, but I think unless we look at this in the context of it's probably going to go wrong and it's all happening too fast, but there's not a lot we can do about that because of the nature of the crisis, then that's really, it's going to end up in difficulties.
Can I just counterpoint what Adam said? I mean, I entirely accept that we're in new territory, that legislators and the people who advise them, government ministers and the people who advise them, are in new territory. But it requires a level of humility on the part of those who are doing these developing apps, whatever they're doing, new procedures. I mean, even deciding whether there's going to be an easing of lockdown or whatever. It requires a level of humility on behalf of policymakers. And if they're not listening, despite the scrutiny that Adam says is necessary and is taking place. I mean, frankly, most ministers on the app discussion, for instance, which is the subject today, and on the legislation that's needed around it, have completely stonewalled it. I mean, not to put too fine a point on it. Obviously, our experts are not politicians, but it's my job to try and see that the best advice that's coming through is reflected in what is actually happening. And I don't see that. I don't see that ministers are saying to themselves, oh, that's a great idea. Let's pick that up and run with it, because that will then increase public trust. We had about 177 academics in the technical and legal field write to government in the middle of April saying that they thought that the development of this app was unsatisfactory. Did they take a blind bit of notice? Absolutely not. And we have a former ambassador who has no technical background running NHSx who thinks that we all ought to accept what we're given. And I don't accept that.
Absolutely. Perhaps combining what the two of you just said there, Tim and Adam, in this time of crisis, if people were communicating along the lines of, yeah, that this may not work, but let's give it a go, there'd be a sense of we're all in it together, and humility, and that might hugely, as you're saying, impact the buy-in, as opposed to the sort of traditional British sort of folding arms and leaning back and thinking, yeah, they're out to get me.
The opacity of the Isle of Wight trial
Yes.
is extraordinary. We don't even know what it was designed to do, actually. Lilian may have been told in the Ethics Advisory Board. I doubt it. They certainly weren't told in advance of the Isle of Wight trial as to what it was meant to accomplish, and therefore all the criteria were set out in advance. That is not the case. And, you know, that's when you have a project like that, which has a lot of ethical issues involved in it, that's what you need to have. That's what you'd have in a medical trial, for instance, and that's what you should have in a trial of this kind. And we still don't know really what the outcome is. And the outcome seems to be that a whole bunch of people in Hampshire and other places, not the Isle of Wight, have been signing up to the app. And yet the government seem to think that this is a high rate of sign up in the Isle of Wight. So, I mean, who knows? Yeah.
Isn't it a case that the app is kind of trying to do too much? I think with all good IT, government-led IT projects, that the scope is usually very wide at the beginning, and it slowly but surely kind of narrows down as we get to the crux of the matter. And I think one of the commentators in the chat box has also mentioned that, you know, are we not doing two things? Are we not doing one, on the one hand, trying to augment the manual contact tracing, but on the other hand, also trying to get people to donate, in essence, their data by self-declaring and then affirming a test, which they then said, I've got COVID-19, for then research purposes? Would it be better for us to split those two kind of ideologies there, actually, to make something more perfunctory in that regard?
I just want to come back on what Lord Clement-Jones said. I think that put it in a much better way than I did. I think that's exactly right. One point I wanted to raise on that is that there seems to have been there's a difference in tone that fluctuates on this app between the politicians and the scientists who are involved in it. So I've been reading some of, I think is it Ian Levy's blog posts about the app. I think have been really interesting and really good. Exactly the kind of tone, you know, very open, and this is what we're trying to do, and these are the potential issues. And that is exactly what you need with this app. But I do think there came a point around the Isle of Wight trial where the government started to get quite a lot of criticism over on a number of different issues, and at that point they seem to have shut down that approach, as in we're not going to be doing it open source anymore. We're going to be doing the sort of more Yes Minister style. Yes, we'll engage with the public when we are forced to engage, but otherwise we're just going to crack on with this. But the point you made about public buy-in seems to be the overwhelming point, that if the public don't trust the government and the NHS, and the public don't trust the government and the NHS with their data, then it's not going to work, because they need, I mean, depending on what you read, they need at least 60% of the population to take this up to make it really effective. And that seems to be, just seems to be a misstep and a kind of almost like an egotistical approach rather than an effective approach.
And if they'd really thought about it and thought, well, how do we build public trust? Actually, picking up the ideas for legislation that both of you have put forward would have been an ideal way of doing this, basically. You know, I mean, I don't know what the take up in Australia has been. Maybe either or both of you will know that, but it seems to me that that is an essential brick in the wall to build public trust. And that's really why we're talking about it today. But isn't it extraordinary that all the best minds think this is the way forward and have been completely ignored?
It's interesting with the Australian example, there are 6 million people who have taken it up of a 24 million population. And again, it's a one island, you know, like we are a one island app, that will be a one island app. The only difference being that their technology is based on that trace together foundation, unlike ours, which is obviously very new. Just obviously Lilian wants a word there. If you could respond to what you're going to say.
I mean, firstly, our app is based on Bluetooth proximity, Bluetooth low energy tracing, and in that sense, it's as new or as not new as pretty much the Australian app. Actually, it's not that different. It has also a centralised architecture. It collects more personal data, less pseudonymous data. As Tim said, I think that was a very good and rather unexpected decision, and I'd really love to know what fell behind it for them to issue our law, which actually was a binding law, though it's been replaced. It was a determination, whatever that means. It's been replaced by a later statute, but they did issue binding law at the same time as the app and at the same time as the DPIA. Now you can argue that the DPIA should have come earlier, but still it was quite an impressive strategy and it did seem to get some traction. On the other hand, right, because I'm generally a gadfly in these things, I think it's now up to about 9 million people that have downloaded the Australian app, but this has resulted apparently in one person being traced and told to stay at home. Right, now this is partly because Australia already had a very low incidence of COVID-19 and because it's an island, because it's not, you know, full of international travellers, but it's still a kind of salutary tale. And, you know, again, to step outside of my expertise track, in the end, this is not about storing up data. In the end, this is about delivering instructions to people to stay home and self-isolate. That's what it's for, yeah? If you separate it out from the long-term research project. And as we've just been saying, some kind of degree of trust and confidence and solidarity, and this is a social project, is essential. I mean, I say I'm someone who I think has had it. I didn't get tested at the time, so I don't really know. If I got, but I had the loss of smell and taste, so it's pretty likely. If I got a message from an SMS text telling me to stay at home for 14 days because I'd been identified as a contact, I'd be pretty fed up, to be absolutely honest. I mean, in public, I should say, of course I would do it, but I'm sure it would cross my mind that I think I'd had it and am I really at risk? Now, if you take the entire population as a whole, you can say that the greatest obstacle to that trust and confidence and social compliance has been the discovery that you can take your own view as to the quality of guidance, not law, that you are given, right? And I would, for example, hypothetically, take into account my own view that my work is important, and maybe that means I can't self-isolate, and thus I think I've had it, and therefore I'm not a risk, right? So we have just gone through in the last week, I think, the biggest blow to the success of the whole manual and digital app tracing enterprise, which is that I think people are now not convinced that they should accept guidance, but that they should evaluate it themselves. The last thing I'd say, more on my own expertise, is I'm very curious about the choice of the commissioner, the Digital Contact Tracing Human Rights Commissioner, in the Human Rights Bill, because it's incredibly narrow. It only relates to the contact tracing app. And as we've just been saying, and maybe this was less obvious whenever it was 3 weeks ago, the app is, if anything, a kind of bagatelle, a kind of jewel on the front of the much bigger enterprise of track and trace, test and trace altogether. And therefore creating a new commissioner I support, but creating one that's that narrow, that doesn't even extend to the future of immunity certificates or manual tracking or the dashboard, such as the Palantir dashboard, seems strange. And I just wonder again what the thinking was there.
Just only one thing I'd say about what Lilian had to say, a huge amount of which I agree with. But of course, one of the purposes of, even if the track and trace doesn't actually track and trace anybody, it's about confidence building. So that, for instance, people sending their children to primary school today actually feel that there is a system where if people do contract COVID, that there is a way of identifying them and isolation and so on and so forth, so that we're not going to be into a second peak and so on. So there is a kind of intention there, which even if, you know, I mean, I'm not quite sure quite what you were saying about the Australian app, Lilian, being effective or not. You know, even if you don't find a single person, as long as it's working, you know, and it provides confidence and people start getting back to normal. I mean, one of the reasons why an awful lot of primary schools are not opening, you know, for the particular classes they're allowed to open for today, is because people don't feel confident that there is a full track and trace and isolate system in place. So, you know, I mean, I agree, you've got to create the conditions in which you have an effective system, but it's pretty important we get it right.
And that confidence piece, Tim, is coming through on the questions on the chat. If you can see that, let's just turn to a couple of those. I've got one eye on our time as well, but you can see from Stuart saying that in the bill, the digital contact tracing bill, there's a requirement for the NCSC to give the app a clean bill of health, which they haven't necessarily. And what happens if they don't? There's a trust and confidence piece. And if you align that with a comment that Roger's made from one of his German data protection colleagues saying that would you rather give your data to the government or to Google, Apple? So I wonder what the panel think in terms of this piece around confidence and how to gain confidence so that we actually do, as Ada Lovelace Institute put it, exit through the App Store.
Well, I could answer the Google Apple question, I think.
Please.
Saw that earlier. I mean, it's not that I'm not in any way working for Google Apple on this, but my understanding of the decentralized protocol is you are not giving your data to Google Apple. That's the whole point. Your data stays on your phone. And then by the miracle of technology, which I don't fully understand, in a privacy preserving way, they do manage to pass alerts to the contacts of the potentially infected person. And another point to make actually about the decentralized system, which has had sort of less play in this country, I think, is that it was based absolutely explicitly around contacts only being triggered by a positive test. A lot of this goes back to historical accidents, these choices. Because we didn't have testing, we had to rely on self-reported symptoms. Self-reported symptoms can go badly wrong in ways that we haven't quantified. And that led NHSx to say we have to have a centralized system where we can do risk scoring, which is essentially a form of machine learning on the reports of infection that we receive. So in a way, what we've done is a bit of throwing good money after bad. We started in a bad place of not having enough testing, unlike places like Germany. And we ran after it with a centralized design, which is now proven to be not great for trust and confidence. And I think, absolutely, I think everyone takes the point that these decisions were made in the best of faith in emergency, unfortunate situations. But I sort of take what Lord Clement-Jones was saying, which is one of the features of the UK response, the UK governmental response, has been an unwillingness to change their mind, to turn around in the face of the evidence. We've seen this with masks, we've seen it with PPE, and now we're seeing it with sort of testing versus self-reported symptoms. And I don't know if I'd use the word humility. I don't know if I feel, you know, empowered enough to use the word humility. But I think there is a continual practice of simply refusing to say, well, at the time that was the best we could do, but now we can do better. And that's partly what's leading to this sense of obfuscation. And I'm not a politician, but I do myself as a punter find that unhelpful.
Well, I would just like to nip in now to say I'd like to thank everyone who's spoken today. Thank you, Lord Tim Clement-Jones, Professor Lilian Edwards, and also Adam Wagner. Thank you very much for all your contributions today. I think we've done quite a deep dive into the two pieces of legislation. I believe that we've looked at, you know, whether we have overconfidence or potentially underconfidence in the way forward in this. I believe personally it would be very nice to see the gap analysis of law to come forward into our parliamentary books to affirm the other existing legislation we already do have, as Lilian quite rightly pointed out. I think an interesting word to end on outside of the word safeguarding, which is what we're really all talking about here. We're trying to safeguard people, safeguard society, safeguard those who are shielding, safeguard those who want to be mobilised again as well, is also one of humility. And seeing the German example where they started with a centralised app and then went to the DP3T protocol of decentralised app, and the ideology of a donation of your data for public health purposes. I think that's something we need to be considering as a nation, that we need to be thinking about our humility of approach here. If something is not going as it should we be turning back and making a U-turn, or should we be saying, let's stop here, we've had some lessons learned, where can we move forward on from here? So I kind of implore to both our speakers today and to our audience who are listening online, what is going to happen next? Do we make a U-turn? Do we make a fork in the road? Do we put this legislation on our books? But whatever you can, wherever you're placed, I would love to see you be proactive in this sphere and make it forward. If you want to write to your politician, or even Lord Tim Clement-Jones, if you'd like to put some word in for us in the House of Lords to try and get this moving forward. But whether it's the one bill or the other bill, or a combination of the two, which I think would be the most effective, we certainly need a better, more safeguarded and more humble approach going forward.
Thank you for joining us today. This webinar has been recorded and will be available on the SCL website, along with many other online resources and training modules. So please do go and take a look. Membership of SCL is open to all. If you're not already a member, joining details can be found on our website. Membership is free for trainee lawyers and for students. If you'd like to show your support for SCL, and in particular our student schemes, please buy SCL a coffee at buymeacoffee.com/SCL.